My business partner, Reddy Neumann. Where have you been, Emily? You haven't been there.
Had a much needed vacation, but I'm glad to be back and get everybody ready for these adjustment of status filings that we're hoping to come up in October. So one of the things we wanted to talk about today was the process of the actual interview, as we are seeing more and more people are receiving interview notices for the applications that were filed last October. During COVID times, many of the interviews were waived. That seems to be going away, and we're starting to see more and more people interviewed, so we want to make sure we discuss what that process is like so you can be prepared. Also want to discuss the new changes to F1 application filing when you're filing a change of status due to long processing times, and discuss what happens when you have filed your 485 and you have your EAD and you want to start a business, you want to be self-employed. Is that an option? So we'll talk about all of those things. So let's say the interview notice comes in and you have to prepare for your employment-based interview. How much time do you usually have to prepare?
Typically, we used to have about 30 days assembly, but nowadays I noticed that they're giving 10 days notice, 15 days notice, because they want to hurry up. The methods that what we have used, people have contacted the congressmen, and that worked out. And a lot of people are getting the green cards. A lot of people are getting the interviews. A lot of people are getting RFEs about the medicals, which is exactly what we allow. A lot of people got text as messages. A lot of people got emails about the medicals, but they're waiting for the RFEs to come in. But yeah, it's taking, right now what I noticed is anywhere between 1 week to about 20 days is what I've seen recently for the 485 interview. Now, when you get the 485 interview notice though, there are certain things that I want you to make sure. If you have submitted the 485J supplement, you don't have to submit the 485J supplement again unless if you're not employed with the same company, unless you don't have the job offer with the same company. If you're working with the same company, you can take an employment letter, verification letter that you still have the job offer. You need to take that. I strongly suggest that people who will go for the 485 interview need to have a copy of the I-140 petition that also has a copy of the labor certification and also have a copy of the 485 application with them. Now, for you to get a copy of the I-140 petition, you can go to the link that we have provided in advance. We want you guys to prepare these things in advance, not when the things come in. So you can go to the link provided at the I-140 petition. You can, it takes about 10 minutes, it's free, it's online. Get that thing ready. Now, your lawyer will definitely provide you with the 485 entire petition. He may not be at liberty to provide the I-140 application, but he will provide you the 485 copy of the entire petition. When I want you to have these applications, have this copy of the petitions with you so that you can review it to see if there is any difference. You can always contact your lawyer to discuss the options though. Now, when you go to the interview, I want you to dress up completely in Western dress, very professional. If you wear a tie, I want you to wear a tie. If you can possibly wear a coat, wear a jacket, wear the same kind of color code that if you can, same pants, shoots. These are absolutely necessary. Even women should wear the traditional Western dress. Now, unless your religion doesn't permit you where you can wear a Western dress, we strongly recommend you wear a Western formal as possible. Some of these lawyers have suggested go to the interview just like the way you go to temple. Well, they don't know that in temple we go in shorts. Yeah, we do. What they meant to say is that when you go to church, if ever you want to check out how people dress up, wait on a Sunday afternoon out of the church, or go into church and check it out. Nothing wrong with it. See how they dressed up. They really dress up when they go to church. So we want you to, when you go to the 485 interview, completely Western dress, because you are telling the officer that you're respecting the office for which they are serving for. They will really like it. I want you to take all the immigration documents index them properly when you go in there so that you can feel whenever the officer asks you, you can give that particular documentation. I want to make sure that you take the old passports and the current passports, not just the current passports, but the old passports also. Recently, I've noticed that they're asking for the pay stubs. They're also asking for the income tax returns in some cases though. You may find that you may get the income tax returns and take it with you. Also go to irs.gov. Fine, you'll get about 4 years income tax returns. Try to get them and keep it with you. They may be asking about the W2 forms also. We have noticed previously they didn't used to ask, but nowadays they're asking the W2 forms when they go in there. When you go in there, you have the interview letter, you have all these documents. I want you to scout around that area. Check it out. When you go for the interview, where are you going to park there? What time are you going to go there? So if the interview is on Monday or maybe next couple of weeks afterwards, I want you to scout around that area, check around that area, see where you park. Don't go on that day and get bombarded. You already are tensed up, I know that. So try to go and scout around that area. Try to be there at least 40 minutes before. It'll be very much like airport-like security where you enter into the building. They want to see your interview letter so that they will allow you inside the building. Once you go into the building, they will tell you to keep the interview letter at a particular place and they will tell you to sit down. Normally, if the interview is in the morning time, things happen at the proper timings. But the interview is at 11 o'clock, 12 o'clock, 1 o'clock. Then what happens is that by the time the officer gets to your file, they may get delayed and there may be some delays. Morning times will go normally, afternoon time sometimes. You may expect to wait for about 1 to 2 hours at that point of time. When you go in there, when you sit in there, they will call your name. You don't have to very panically listen to the name. They know you are there, so they will announce it, and they know that the names are confusing. This is an immigration officer going. There are a lot of different multinationals people there, so they're accustomed with the name. So they'll go around and check around to see if the person is there. When the officer comes out, announces your name, they will escort you to a small locked door. They will open the door with their card. They will tell you to go forward, and they will come and they will escort you to the officer will escort you to that particular officer's room. You may have to walk through a couple of corridors to get to that room. The room normally is a very small room. It may have an outside window. It may not have an outside window. It will have a desktop computer. The monitor will be either on the left side or on the right side. They always like to have the main applicant sit at the opposite side of the monitor. Let's say if the husband is the main applicant, wife is the dependent. If the monitor is on the right side, the husband will be on the left side. In the desktop, where the officer sits, there'll be 4 chairs. 2 chairs in the front, 2 chairs at the back. As I said, wife and husband, they normally tell you to sit in the front 2 chairs. If there are any kids, they will tell you to sit at the back side of the back. There are 4 chairs at the back of at the 2 back chairs, they will tell you to sit. Now, once you go in there, they will ask your driving license, your passport, your EAD cards, and they will tell you to stand up, and they will tell you to raise your hand, and then they will tell you to repeat after them that you're going to tell the truth, nothing but the truth, and your answer should be yes. And after you do that, they will tell you to sit down. Once you sit down, they normally will ask questions, routine questions. What is your date of birth? When did you last came into the United States? What is your mom's name? What is your dad's name? What is the address that you live? They will ask the basic questions. Some of the officers may ask you, is your date of birth July 3rd, 1984? Some of the people may ask, what is your date of birth? So either way, it's the same question, routine questions. Once they go to the routine questions, though, they will ask the 485 questions. The 485 questions are, have you been involved in a crime? Have you been arrested? Are you a Nazi? Are you a communist? If you read the 485, those generic questions that are there, somewhere between 4th page and 6th page, there are some generic questions there. I'm sorry, some 7th page and 12th page, there are some generic questions. In those generic questions, though, you will see that if you read the questions a day before, you don't have to by heart those questions. You don't have to. This is not a citizenship test. So you just read them, glance them through once. So when you are there, when the officer is asking the questions, you're comfortable. If it's a traffic tickets, they normally don't ask anything. But if they particularly want to ask about traffic ticket, you can just mention it. We haven't seen any officer asking about the traffic tickets unless you mentioned it on the 485, which you are under no obligation to mention about the traffic tickets. If you do have any criminal records, you definitely need to make sure that you have a consultation with a lawyer before you go in there, so that other than traffic tickets, you should. Now, they will ask you about your employment history. They will ask you about how do you got the job. They may, if there is a salary variation between what you are getting and what's said in the employer letter, what is said in the 485J supplement, it's okay, not a problem. If you're working at a different location than your employer location, especially if it's a consulting firm, it is not a problem. It's okay. You can mention that my company places me at a different locations. That's not a problem. After the interview is done, if the officer feels comfortable, they'll say it's approved. Sometimes they'll say, I'll go to the supervisor. That means everything is clear. If they say, if they issue any of the documents, for example, if the birth certificate is not proper, maybe if the medical is not proper, they may issue a called I-72 or request for further evidence at that point of time. We rarely see those kind of things. If you are well prepared with all the documents, we rarely see those kind of things right now. Any other special instructions you feel about the 485?
Yeah, I think you covered everything.
Emily, what about if the person has never been employed with that company and he's going for the 485 interview? Will that be a problem? Is it a mandatory that they have to work for the company?
No, there is actually zero requirement that you actually work for the company that is sponsoring you for this whole green card process. It's all based on the future employment, the job offer that they have made to you. And so if you are intending to work for that company and that company's job offer is still available to you, you should bring an offer letter from the company confirming that the offer is still available. If you've already moved on to another employer and no longer intend to work for this employer, make sure that new employment qualifies for AC-21, meaning it has to be same or similar job to what you were sponsored for, and you should then bring the supplement J to the interview. But either way, even if you have never joined that company and have moved on to a new company and are bringing that supplement J, there's never a requirement that you had to work for the company that offered you the position that's supporting your green card process. USCIS has made that very clear in their guidance documents.
I want to also stress that all the people who have not contacted the congressman, we did provide the link right now to contact the congressman. Your efforts have definitely changed it. There is we can see that rush in the 485 processings right now. Thank you for all the best things that you've done. We also issued some fresh questions for the Charlie State Department, why they are completely disconnected with the reality world. Don't try to send, not everybody send the letters to Charlie. He doesn't like many emails coming from us. At least if we have about 100 or 200 emails, that's fine. But I want to make sure, and the draft is also provided at the bottom of the things. If you guys want, if you feel that these questions are the ones that need to be answered by Charlie, you do it, but don't make it as a mass effort though. When it comes to the writing the letters to the congressman, please do write letter to the congressman which is sent. We also created a separate letter that you can send to the Ombudsman of the Customs and Immigration Services. It is provided at the link. We strongly recommend, if you feel those suggestions that we're suggesting to the Ombudsman are right, I want you to modify them to your needs and write your personal story in them. When you write the letters to the Ombudsman, they need to understand what's going on, and if you feel that those things we have just given the draft, make the necessary changes, write the letter to the Ombudsman. So please make sure that you send letters to the congressman, send a copy of that letter to Joey Lofgren, and also send an email to Ombudsman, so that how effective your letters was there. I mean, we can see the momentum in the 485 applications. Thank you for all the efforts that you have done. Good job, guys, that what you have done. It definitely is eliminating some of the waste green cards that would have gone wasted. But we don't want anything to be wasted. So we still want all those people who have not written letters to the congressmen should write letters. All those people who have not, everybody, because we just drafted this ombudsman letter. We want everybody to send an email to the ombudsman, whatever you feel. You can use the format that we sent, but it doesn't have to be exact. You can change the format if you want to. Please make sure that's been done. Emily, what are the updates on the F1 visa? It seems that previously when people were on aging out, people were on coming on student business visa or visiting visa, and they changed. When we file a F1, we have to keep on filing the B2 extensions or these kids who are getting aged out. We used to file the B2 as called bridge applications. What's the change right now?
Yeah, thankfully USCIS has changed their stance on that. There was an announcement on the USCIS website confirming that once you file the change of status to F1, as long as you are maintaining your status at the time of filing, you do not have to file a B2 bridge anymore. You can remain in the U.S. based on the pending change of status application, and USCIS, when they finally get around to it, will approve it even if your previous status has expired before they get around to approving your F1 change of status. That's a huge win. It is going to eliminate a lot of unnecessary filings, improve efficiency for the government, but it's also so much better for especially these kids that are aging out, turning 21. We were telling people, don't wait to file your change of status to F1 until you're 20 or 21. File it at least 2 years early because the processing times were so long, and we wanted people to avoid the need to file these B2 bridges after they aged out. So this is a huge improvement in the process. I think it will help with processing times for the F1s because we won't have to worry about people adjudicating the B2 and then trying to figure out. There were so many cases that got messed up even for the people that just followed the process and filed their F1 and then filed the B2 and then filed the B2 extension, and then somehow they end up getting a B2 approved and the F1 gets denied, or the F1 gets approved and dates are all off. USCIS couldn't even figure out how to process them properly because everything has a different time frame, and you file these things after months and months and they can't put them all together. They get confused. So this will certainly help the process for those looking to change status from dependent H4, L2 over to F1 if they're in an age out situation.
Emily, sometimes these people, immigrants are more entrepreneurs, and they file the 485 application. What if they want to be self-employed? Can they be self-employed in the 485 application?
Yeah,
I'm not speaking about the dependent employees. The dependent people who are on EAD, there is no restriction at all. They all know that. They can be, if the dependent, not the main applicant, if the dependent got an EAD, they can flip a burger in McDonald's, they can be a lawyer like you, or they can be a Microsoft CEO. That part they know. What if the main applicant wants to be self-employed? Can they be self-employed?
Right. So for this, you do need to have the EAD before you can take that jump, because the H-1B, the L-1, they are tied to a specific employer, and self-employment is generally not allowed in those visa categories. Now, the other thing besides having the EAD, you need to make sure that your 485 has been pending for at least 180 days so that you qualify for AC-21. AC-21 allows you to take your green card process with you to a new employer as long as the job is same or similar to what you were sponsored for. So here, if you're going into self-employment, using the same skills, doing the same type of job that you were originally sponsored for, you can use that self-employment to keep the green card process going. Your other option is you can work for your sponsoring employer, and we have some people that want to start a business on the side. Maybe they're not ready to go full-time with their side hustle yet. You can do both of those things as well. You use your EAD to keep working for the employer that sponsored you, and that process, they will continue to be the sponsor throughout. You don't need a supplement J in that situation. and you can start a business on the side. If you're going that route, it doesn't matter what the business is. It doesn't matter if your job is in same or similar to what you were sponsored for, because your sponsorship with the original employer still continues. But you do have the option of going out on your own as long as the job is similar, and you would submit the supplement J when you're called in for an interview or in the event of an RFE on that.
I would strongly recommend those people who are self-employed, if you get a call for the interview though, always take the lawyer with you, because sometimes it may take a little bit explanation from the lawyer to the USCIS officer so that they can understand what the process is. And I was speaking about one thing I missed about the 485 interview. When you guys are going, will you be, is there anything I can make your tense less? No, nothing. You'll be tense. I bet you'll be tensed. Believe me, you'll be tense. If you won't sleep at all the day before or 2 days before, well, there's nothing wrong. That happened. Now, this is my personal experience though. Before I went to my own 485 interview, which I actually was a dependent, my wife was chilled. The tension was on me. Before I went for the interview, for 2 days, believe me, I did not sleep, not a single minute. Now, before I went for my 485 interviews, I have attended as a lawyer for 50 other interviews. I was a very junior lawyer in that law firm. That senior lawyer just used to send for all the interviews. I was there, I was fine, I was not tensed at all. And I know what goes on in there, all the things. I know every proper documentation is there. I should get approved, but I still did not sleep for the 2 days before. So when people ask me, is there anything that can make you cool down? No, I couldn't do it for myself. How can I make it for you? No, it's normal. You will be tensed. That's nothing odd about it. I have experienced personally myself how it is. There is nothing I or anybody, no lawyer can do anything for you to cool down. It's normal. That's just the way it works out. Let's go to the questions, Emily. Questions that came out is that, can I take the child who's a US citizen to the 485 interview? Now, previously we used to just answer yes to that question though, but now with the COVID restrictions, I'm not sure if they would allow the kid, or let's say, for example, if your wife and husband, they may tell the husband to stay with the kid, and if the wife is the main applicant, and vice versa though. I don't know the experience at this point of time recently though, but I may be able to update as you guys give me more feedback and what happens though. Previously, they just used to allow, it was not a problem. Kids were allowed, even though they are not part of the application. They were allowed to go in, but with COVID, we are not yet sure whether, if they don't allow though, I mean, it's not that they're going to cancel the appointment. They will do the main applicant first interview, they'll do the dependent later on. So the main applicant will go through, the dependent will stay with the kid, and vice versa, they will do it. That has seen that. Anup got an RFE for I-485. Should it be for medical? In the past 1 week, and thank you for all your efforts that you've done. You're getting RFEs because you wrote a letter to the congressman. You're getting RFEs for medical. Most of the RFEs that were been issued in the past 1 week to 10 days, where most of them for the 485 has been for medical. And Emily, one other thing, we have received a notice of intent to deny for a lot of people who filed the 485 recently. And you know that we are never happy for notice of intent to deny. This is the only notice of intent to deny I was so happy. Why? They're asking notice of intent to deny because submit the medicals, otherwise we're going to deny. And they have only given 30 days to respond. In the RFE, you get 87 days to respond. In the notice of intent to deny, it's only 30 days. They want to act very quick. They really want to act very quick on your 485 application. I was so happy to see this notice of intent to denies. Because of the USCIS exemption that's there because of the COVID, you have extra 60 days if the RFE has been received right now. But still, why would you spend that extra time? For sure, you'll be the first guy to go to the doctor, and then as soon as you get it, I know you're going to send it in there. I looked into the medical. If it's just medical though, I mean, for our clients, what we're telling them is, hey guys, you're going to send the medical to our office, And sometimes we may not send it to the USCIS the same day. It goes the next day. Why delay? Why don't you just send it to the USCIS? Because we can't even open the medical package when you send it to us to see if it's correct or wrong. So we recommend our clients, hey, you send it yourself, the medical, and you send us a tracking number so that we are tracking with you that that is our policy, but you can check with your lawyers what they want to do it. This is your personal thing. You can control yourself. Make sure if it's anything else other than medical, we don't want you to touch it. We want you to go through the lawyer, though.
All right. Udayan from YouTube wants to know, he interfiled the medical exam 3 weeks ago, but then he got the text from USCIS talking about the medical RFE last week. He wants to know if he should redo the medical now or wait for them to add the interfiled medical. The online case status has not changed. So we're hearing lots of reports of people receiving these text messages and emails, and those do not appear to be directed at your personal case. They just went for people who have a pending 485, letting you know that if you didn't submit your medical and you do get an RFE soon, please reply back as soon as possible so that we can adjudicate and give you a visa number before the end of the fiscal year, September 30th. So for that reason, I would say because you got that text, it does not mean that your interfile didn't work. And we often don't see the online case status change when they accept the medical through the interfile process. You don't get any kind of confirmation of it. The only feedback you would get is an RFE asking for the medical. So I would not assume that the interfiling didn't work. Just right now, sit tight. Watch the case status online, and if you do get an RFE, only then go back to the doctor and get the medical again.
Emily, I want you to be aware, because you're out on vacation for 1 week. 1 week is a lot of changes that happen. This guy, Krishna Bardhan, has received an interview, and he got an RFE for the late birth registration last week, and it is due later in August. Can I bring the RFE response directly to the interview? Here is the thing. Where did the RFE come in? It came from the district office, not from the service center. So yes, it's very surprising that 1 week off is tough for us, for immigration lawyers. Is that, yes, we have never seen these kind of RFEs before, guys. In this case, since you're going for the interview, though, I would do two things. Respond to the RFE, okay? At the same time, take a copy of that with you. Now, if it's a medical, though, I would just take it with you, okay? Don't, because it's only one, you don't get two. Birth certificate, late registration explanation, for getting an affidavits, getting an alternative documents, nothing, they're just copies of those things. So send it RFE response, take it with you, both, do both the things. But we haven't seen this before. This is an unprecedented thing. I think so. It is the reason because that you guys wrote so many letters to the Congress people. You sent copies to Joey Lofgren, and I think so she responded. I just want to tell you who's the USCIS chief right now, I believe.
Yeah, we do finally have one after, 18 months without having a confirmed.
Is there any influence from the Congressman Joey Lofgren on this?
Yes, this particular person was actually working with Zoe Lofgren's office for about 5 years prior to joining USCIS. So that's a very good sign.
Yeah, it's like Rebecca Chen in our office becoming the USCIS chief. And that's that. So definitely your letters have helped, and these are the kind of RFEs that we are seeing. These are the kind of actions that we are seeing. Less time for you to go for the interview. I don't mind. I like all these things. These are the practical things that came out with the letters, and I hope so all of you continue to keep writing letters to the congressmen, those people who have not written, and also keep writing letters to the USCIS Ombudsman also.
Yeah, and getting these types of RFEs from the field office before your interview is actually a really good sign, because that means the officer has already looked
reviewed
at your
into the file.
You know, in years past, you would go to the interview and the officer was opening your file for the very first time while you're sitting there going through the interview. And that means they have not reviewed it. They can't approve it then and there. They tell you everything looks fine, but I have to complete a review before I can approve. Now, getting this type of RFE means they've already looked into your file and they're ready to go. So hopefully that's a good sign for you bringing those documents to your interview. They should be ready to adjudicate it then and there.
Renz from YouTube is asking the question, is interview mandatory for the EB2 application category? No, it's not mandatory. They are still waiving a lot of these things. In the past 1 week, we have received a significant number of people who got the green card approved. So which is good news actually. It's going both ways. But previously we made a statement that only 5% of the people are interviewing. We have to change that right now. I would say it's about 40 to 50% right now are the people who are getting interviewed right now. But it will keep changing, guys. We'll keep informing. We just want you to be prepared for the interview, irrespective of whether you'll be interviewed or not. It's not going to be any loss.
Pardeep from YouTube is a physical therapist with a priority date in 2012 in EB2 and wants to know, should I downgrade or wait for EB2 to become current? So there is still an issue with physical therapists downgrading that Schedule A category. We have received approvals, but we've also received denials. It is inconsistent. So there is a chance that you could file this downgrade petition and end up with the denial. So then it was kind of no point to doing it. There's a chance that you file the downgrade and it gets approved, and then you're able to file the 485 sooner. And we have no insight into which cases get approved and which cases get denied. They are seemingly the exact same filings, and some get approved and some do not. So it's very inconsistent. So you really would be just taking a risk, and it's all about, you know, do you want to take that risk for the potential reward of getting your green card or filing your 485 faster?
Amit Duthi Sengupta said she submitted the RFE response within 1 month. She got the green card. Congrats. Thank you. Now she says she can flip the burgers. That's just a joke she's saying. I wish you best of luck. And we did receive a lot of emails from our clients also recently, and also from the outside also. A lot of people have got their green cards approved, especially who have responded to the RFE recently. It's a lot of people that got it. So the faster that you respond to the 485 RFE, there's a great chance that we will reduce the wastage. So it's better that we try to get the green cards in this year itself, so that we can preserve some of the green cards for the next years for the people who deserve them.
Bhushan from Facebook wants to know if initiating a service request, or SR, will help move the application along. Yes and no. So if your application is actually outside normal processing time and you submit a service request, yes, sometimes those service requests can be helpful. They help ensure that your case hasn't fallen through the crack, and they can get things moving. Unfortunately, you can only submit a service request if your case is outside normal processing times. And right now, for all the different service centers and local offices handling 485s, they're claiming that normal processing time is anywhere from 2 to 4 years. So anybody who filed in October of 2020, you're not going to be able to even submit a service request. 1
week on vacation, Emily, you lost in touch.
Oh, no.
It's 62 months. 62 months is the Texas Service Center waiting period.
That is completely ridiculous.
It was 50 months when you went for the vacation. Now it's 62 months for getting it. The question that came out on the I-140, if this came from Sen Abhijit, if he exercises the AC-21, can the employer withdraw the I-140? Will it have any impact on it? If you exercise the AC-21, assuming that your I-140 is already approved, assuming that it's more than 180 days since you file the 485, you exercise the AC-21, no impact on I-140 withdrawal. It will not impact your 485. That is the whole purpose of the AC-21, that if they withdraw, it should not affect your AC-21. There are a lot of people who will debate whether they can withdraw, they cannot withdraw. That's a different issue. They can withdraw it, they sometimes do it, and sometimes they're under obligation to withdraw, especially when they want to prove that their ability to pay, since you left the company and you're not on the payroll, it's okay for them to withdraw it, but it's not going to negatively affect if you completed the 180 days. A lot of people ask this question, do I have to wait for 180 days after the I-140 is approved? No, you don't have to. In this AC-21 exercising, changing the employer, you do not have to wait for 180 days after your I-140 is approved. It's only up to 180 days after you file the 482 application.
Ankush from Facebook has both an EB2 and the EB3 I-140 approved with the priority date in December 2013. He wants to know if it does get current in the September Visa Bulletin, do we recommend sending in the medicals with the 485? Are there any disadvantages, assuming money is not an issue? I really don't see any disadvantages as long as getting the medical does not delay your filing of the 485. Sometimes, especially in October when there's a big rush, it can be very difficult to get the appointment for the medical exam, and you don't want to delay the filing so long that you miss the boat on the filing. So that's one of the reasons why we sometimes recommend to not file with the medical, is when it's a month where there's a big rush. September probably won't be a big rush, so you may be able to do that. I don't really see any other disadvantage other than it might expire if the 485 processing time takes too long, but if money is not an issue, you can always get another one done before they approve the application.
Hosuru family, my daughter is aging out on January 21st, 2022. January 21st, 2022. I-140 took 7 months. Will that 7 months will be added to her age to become 21? That's right. It's not added, actually, it will be deducted from her age. So it will be, if the 7 months is the period that is pending, she will be aging out in August of 2022. So if the final action date becomes current by August of 2022 though, she is locked in, she's fine. So you didn't put the final, you did not put your priority date, so I couldn't figure it out. One thing that I would suggest you though is that make sure that she doesn't use the GCEAD if possible. Because if the final action date becomes current, she's fine. If it's not, before she uses EAD, I would definitely recommend that you consult a lawyer.
Sarjit from Facebook wants to know what kind of questions are asked in the 485 interview. And Rahul did go over that at the beginning of the video if you want to take a look at that. And I would just say probably 50 to 75% of the interview is spent reviewing all of the answers that were given on the 485 form itself. They ask the same questions: your name, your birth date, kids' names, kids' birth dates, spouse's name, spouse's birth date, when did you get married, where did you get married, employment history, address history, and then all of those questions about, are you a communist, are you a terrorist, are you a criminal? So if you review the 485 form that was submitted, that 20-page form, that's going to be the vast majority of the interview itself, and then Rahul discussed some of the other common questions that are asked at the beginning of the video.
Questions from Urjita. She's partner in the Indian firm, and can she continue to be partner? Now she's on H4 in United States. No salary won't be withdrawn. If there is no work involved to be a partner in that company, definitely you can continue to be a partner in the Indian company. And if there are any profits that are derived from there, you can get the profits. As for the salaries working, now the US, the governments in the world right now, they do not recognize cyberspace as a space. They only recognize as where you sit at. If you're sitting in United States, if you're working, that means that you must have a work permit in United States. They don't look into where you log into, whom you called, did you use the internet phone? That's not the issue. It's more like where you actually are sitting at. That will determine whether or not, That will determine. So you cannot work here, but if you're a partner getting the partnership benefits, that's perfectly all right.
Sen from Facebook wants to know, what is the impact of the employer withdrawing an approved I-140 if the employee leaves?
I already,
oh, sorry about that.
Yep.
All right. Swati wants to know, after the interview, is it common to give the I-485 interview results notice with option 1? At the end of the interview, depending on the officer and depending on the case, they can tell you right then and there that it's been approved and give you a notice. It really depends on whether the officer has had a chance to review the application prior to you coming in, or if they are looking at it for the first time, and then if there's anything that they have to look into further before they can approve. So there's not really any, only one way that they do it. It depends on the particular officer.
Question, is there a chance for third lottery, Emily? For the H-1B they are asking about. Very less chance at this point of time, but if there is any changes, we will let you know. You know, it's very, I would definitely, if I were you, I would, if I were you, I would have an alternative plans.
Amit from YouTube says his EB3 priority date is current, but the online case status says there's an RFE. But the only letter he received in the mail appears to be a 485J receipt notice. Should I expect another letter about an RFE? Yes, I would. I don't think the supplement J receipt was the letter that they were referring to if they're specifically saying we sent a request for additional evidence. So if you have not received anything within 30 days of when the online case status notice that they send that letter, that's when you can do a service request online through the US CIS portal for not receiving that notice and have them send it to you.
Can I, Jayasri is asking, can I use the EAD approval to extend the driving license? Yes, Jayashankar, you can. It will not be considered that you are married to the 485 application if you use only for the driving licenses. NK Bharat from YouTube asks this question, would you recommend interfiling medicals as against waiting for the RFE? Only right now, because we are seeing a lot of RFEs right now. I would wait. Previously, we told different things, but we have seen a lot of RFEs right now on the medicals. I would wait for at least 2 weeks before I determine whether, you know, or you can follow our on the YouTube and Facebook. We may tell a different story in 2 weeks. For now, I would wait. That's my opinion right now.
Pradeep from YouTube had a family emergency, had to travel to India and missed his biometrics appointment while he was overseas. He wants to know, what are the next steps? So USCIS actually recently changed how they do the rescheduling process. It used to be that you would mail back the biometrics notice to an address in Virginia, and they would take care of the rescheduling. They've closed that office in Virginia, and now the only way to do a reschedule is to call the 1-800 customer service number and ask them to reschedule the biometrics appointment.
Hari from YouTube asks this question, how long it will take for the USCIS to acknowledge the premium processing for the I-140? Hari, assuming that this is a downgrade application though, we not 100% of the cases are getting accepted from the USCIS for the downgrade. Sometimes we have to file many times, but typically we see that within about 10 to 15 days you should get an acknowledgement for the premium processing. If you don't get it, there is a good chance between 10 to 20 days you will get the rejection of the premium processing. Please note that it's just the rejection of the premium processing, not the I-140. When that happens, we normally turn around and file. We file. And there are some cases that have been refiled 5 times, 6 times. They've been accepted the 6th time or 7th time also. That's what is happening with the downgrade application, especially since the labor certification expired. Labor certification is only valid for 6 months, and because you filed a previous I-140 using that labor certification, the lifespan of that has been extended, so the USCIS can, up to their discretion, deny the premium processing request that you do. But if you keep on filing it, they will take your money one time or the other, at least 95% of the time.
Rishi from Facebook wants to know if there's any update on October filing of the 485 for an L1A with an EB1 application where the biometrics have already been done and the medical was interfiled. It's just across the board right now. I have cases that we filed in May of 2020 in EB1 that are still pending, and then I have cases that I filed in September, October of 2020 that have already gotten approved months ago. It just depends on the particular office, the particular officer, whether it goes to a local field office or not. And unfortunately, we just can't do any kind of service request to follow up or expedite it because they're still within the normal processing time.
Vivek has this question: is it safe to change the 485? My EB3 priority date is July 2014. He's on 485 application. Assuming your underlying I-140 is approved, it's pretty safe for you to move to a different job. If the underlying I-140 is not approved, I would definitely recommend that you contact a lawyer before you change, because technically you can, but it normally involves a lot of risks involved in it if the I-140 is approved. But if the underlying I-140 is approved, I mean, it's relatively safe to move to a different job in the similar occupation.
Prodken from YouTube has a 2012 priority date, final action date is current, and he wants to know what happens to the child if we don't get the green card and the final action date retrogresses and the child ages out. Well, the good news is once the final action date is current, and if that child was able to file the 485 because their actual age or their CESPA, Child Status Protection Act age, was under 21, once that 485 is filed, their age is locked. It does not matter if the date later retrogresses and they age out while it's pending. So once you qualify for Child Status Protection Act and you file the 485, your age is locked in, even if they age out while the application is pending.
One caveat: the I-140 must have been approved for the underlying 485 for the child age to be locked. There are a lot of people are asking about October Visa 2021 Visa Bulletin predictions. I am sticking with my what I have told. I'm sticking with it, and I am also preparing for the applicants who are requesting our offices, pre-preparing the application. I'm making it ready. If anybody is interested in, you can drop an email. We have provided it. If you want to use our services, you can send an email to us. If you are expecting the priority date to be current, we charge a token amount of money, make the entire application ready. That's an investment that we are doing. We're taking only token amount of the money. We expect our big payment to come when the priority date becomes current. So if you want to use the service, you can. The details have been provided at the bottom in the link though. It's good to pre-prepare, make it ready so that when, and we don't charge full amount of money, just a token amount of money we charge, so that when the priority date becomes current, you can be ready, file maybe on September 30th, maybe in the October 1st week. Depends on how fast you can get if there's a 485J involved in it, to file it.
Rajiv wants to know, how are multiple 485 applications processed? Is there any guidance from USCIS? I'm assuming you mean the situation where you have filed multiple 485s. Maybe you had one in EB2 and filed another in EB3, or you filed one as the main applicant and another as a dependent of your spouse's 485. And you can have multiple 485s pending. Generally, USCIS will only approve one, and what they will often do is call or send a notice saying, hey, we are ready to approve this one. We need you to withdraw the other one, and you can withdraw the other one because you know the first one is being approved. So it's usually not a problem.
Venkat TD from YouTube has a very good question. Do you need to have an EAD to change the company based on the AC-21? No, you don't. You don't. However, though, if you don't have an EAD, you have to file a H-1B application because you don't have any authorization to work for the other company. So you have to file the H-1B. So if you are moving from company A to company B, the EAD is not approved, yeah, you can file a you can file a H-1B, and then you can file a 485J supplement and move. If you have an EAD, you may be able to avoid the H-1B. That's only advantage. But it's not a technical requirement that you must have an EAD. It's not a requirement.
Teja from Facebook wants to know, can we submit a service request for fingerprinting? Submitted my application in October. Fingerprinting fee was processed already, but I'm still waiting for my biometrics appointment, and this is the Texas Service Center. So I've tried doing the online service request. There's an option saying that you didn't receive a notice, and I've tried to say that the fingerprinting notice is the notice I haven't received. That really wasn't successful. We have heard reports of people being able to go into their online portal and chatting with Emma about not receiving biometrics, and sometimes that has triggered an appointment being scheduled, but there's just not a lot of rhyme or reason to it. It very much is partly because of COVID and because of their social distancing and cleaning and all of that. They have fewer appointments available. And they're not taking walk-ins anymore. So it's kind of tough across the board, but that's one thing you can try.
People are asking about questions about the USCIS director. You are, her name is, you are, can't pronounce it properly.
Jadu, I think?
Yeah, Jadu. One thing we can say is that overall this administration is quite different than the previous administration. The previous administration was completely anti-immigrant, though. This administration is not. We have seen some changes, just like the way simple, the F1 visa do not have to file the B2 applications. There are a lot of small changes. They are working on it. It may take a little bit longer time. That's the reason why we need a lot of pressure from the Congress. This administration is quite different. Especially she has worked for the Congressman Joey Lufgren. I mean, if there is any congressperson that I like the best, definitely she is the number one that comes in my mind. I mean, she's been fighting for taking the per country limit off. She's been a champion for the IT professionals. Yeah. She's also an immigration lawyer. Mm-hmm. She was an immigration lawyer. She's an immigration professor. Joey Lufgren is immigration lawyer, professor in immigration, and also the person who the current appointed director used to work for Joey Lufgren. So we think so that she will incorporate some of the things. She will try to work on some of the things that will benefit the IT community, and probably will try to reduce the discrimination as much as she can, which is allowed in the law, because remember that the per country limit is not under the authority of the USCIS director. It has to go to the Congress, but the rest of the things, what she could do, I am expecting her to minimize the wastage and certain other things and make it more comfortable for the people. And probably, I mean, for the criminal offenders and certain other things who don't deserve to be, she will be very strict on it. That is what I'm expecting. That is what Joey Lufgren is. That is what the new director, I'm expecting it to be.
Barath from YouTube says, it's been 30 days since we responded to an I-140 RFE in the case's premium processing. We still didn't get a reply back from USCIS. What can I do to get them to approve this? Well, as the beneficiary, the employee that's been sponsored, there isn't anything you personally can do, but your employer or their attorney can actually email the premium processing unit and let them know that it's gone beyond the 15-day clock for premium processing, and that may get things moving. It should result in a refund of the premium processing fee, since they did not comply with the time period. And if that occurs, then they could take more time before approving that application.
Amit Riviera has this good question. Is negative X-ray for TB okay for medical? Absolutely yes. For the people who don't know what Amit is asking about, normally what happens is that they will do a skin test for tuberculosis. And if it comes positive, though, they will take the X-ray to determine if there is any tuberculosis. Obviously, if there's a tuberculosis, then it's a different issue. But having a skin positive, people get panicked and they call the immigration lawyer. What can we do about it? Don't panic, guys. If you are from India, though, there is a chance of approximately 20% that your skin will come positive for the TB. And they will go through the X-ray thing and determine that there is none, and then they will report it. So nothing to panic about it. It's just normal. I didn't see any problem in getting the green card approved because of that.
Alongo from YouTube has an EB2 I-140 approved, where it's been approved for more than 180 days, and also a downgrade EB3 I-140 approved that's been less than 180 days and has moved to a different employer. And he wants to know, can he use the EB2 I-140 to continue the green card process? So if you're no longer with that company, you would not be able to move back into the EB2 category. You're kind of tied to the EB3 case that you filed with a 485 based on, since you have left that company and are using AC-21.
Mahesh is asking the question, why isn't that everybody whose current date received the medical RFE text, though? It's not clear the people who received, why they didn't receive. We are yet to determine whether it is just a random thing that they sent to all applicants in the 485. Some applicants who are dates are current. There is no. We haven't come up to a conclusion. It will take a little bit time for us. The USCIS has not announced anything at this point of time, so it's very hard at this point of time to connect the dots. So Mahesh, so you don't, just because you didn't receive the text doesn't mean that you don't receive the RFE. I hope and think that you will receive an RFE on it pretty soon.
Another Bharat from YouTube wants to know, after approving the primary applicant's green card, the dependent's 485 is still pending. In this case, what is the status of the dependents? So if the dependents were in a derivative non-immigrant status, for example, you were the H-1B holder and your spouse was the H-4 holder, and you filed your 485 and you received your green card, your spouse is no longer in H-4 status because you're no longer an H-1B holder. Your spouse then continues in adjustment of status, that is lawful presence. They can use their EAD to work, advance parole to travel, and continue in that until their 485 is approved.
We strongly like your suggestions, guys, of what we should be speaking, any topics that you're interested that we should be covering. Any suggestions that you want to make, you're most welcome. We just want to, let you know that we are not YouTubers. We are just immigration lawyers, happen to dedicate some time for the YouTube and Facebook. This is not our profession. Our profession is something else. We are very busy practitioners. We have a staff of approximately 100 people. We have lawyers of 18 lawyers. All of them are very competent. So when you try to make an appointment, don't just try to choose Emily and me. We have given, when you go to our appointments, we have given preference. If you want to consult about I-140, whom should you prefer? If you want to consult about POM labor, H-1Bs, F-1s, we have given all the details, though. Sometimes they come and ask me about RFEs and H-1B, and believe me that I haven't done an RFE response in preceding, I don't know, since the time Emily joined, I did not. That was almost like 15, 20 years ago now. So please try to pick the lawyers that are more appropriate for you when you are making an appointment, when you want to speak, because it's a better utilization of your time, your money, and our time also. So you can follow the link of the appointment and the details are given. If you have any suggestions, please post it there. We'll try to comply as much as possible. But this is not, we are not YouTubers, as I pointed out, just regular immigration practitioners just doing this so that we can keep informed, we can have you more activated. If needed, use you guys to contact the congressmen to get the things that what we think are appropriate for you. We understand you very much, and we know how the things work out in the system. So sometimes we use you to write the letters to get the things worked out that are in your favor.
All right, well, I think we're about out of time for today. Thanks for joining us. It's good to be back. Glad to be able to get caught up with all the latest in immigration. Please be sure to subscribe to our YouTube channel if you're watching there, or as well as to our Facebook page, so that you get updates when we do have upcoming videos. And you can always get the latest updates at rnlawgroup.com by subscribing to our newsletter there.
Thank you very much.